Well, let's get started. Hafa and buenas. My name is Neil Weare. I'm co-director of Right to Democracy alongside Addie Martinez Roman. I grew up in Guam, and she grew up in Puerto Rico, and we're excited to be working together on these issues. Right to Democracy is a nonprofit organization that's building a movement to advance democracy, equity, and self-determination in U.S. territories. So as I said, my name is Neil Weare, co-director of Right to Democracy with Addie Martinez Roman. We work to advance democracy, equity, and self-determination in U.S. territories. We approach all of our work at Right to Democracy through the shared values of building common ground, respecting differences, provoking change, staying focused, and avoiding toxicity. We work across traditional partisan and ideological lines, and we do not take a position on status outcomes. We thank our co-sponsors today, the Virgin Islands Bar Association and the Guam Bar. They and the CNMI Bar will be offering CLE credit for those who join, for those attorneys in the audience. And we also welcome members from El Colegio de Abogados y Abogadas in Puerto Rico. And we hope to get CLE approved down the road for all of you. For the conversation today, we'll have a number of guiding questions that we'll be asking. But we encourage panelists to also engage actively in making this more of a free-flowing conversation. We also welcome questions from the audience. You can do that in the chat, or there's also a formal question period. We will have a question and answer at the end, but we will try to work in questions as we go as they are relevant. We just ask that people be respectful to each other and to the panelists. And Paula is going to post our webinar code of conduct in the chat as well. We would love to have you follow us on social media at Right2Democracy. And you can learn more about all of our work at right2democracy.us. We also would love to have you get involved in our work. We co-lead a cross-territorial coalition. If you'd like to learn more about that and how you could get involved, you could reach out to us at info@righttodemocracy.us. So with that, I wanted to welcome our amazing panelists we have today. I will give a very short introduction and ask that each of them share more about themselves, their name, their organization, a brief background on their academic work related to U.S. territories. And if you have a fun fact about yourself and your connection to a territory, either the one that you're most closely associated with or another, would welcome that. And so with that, welcome Professors Cristina Ponce-Krauss, Rose Cuisan-Vilazor, and Sam Ehrman to join us today. Cristina, do you want to go ahead and introduce yourself?
Thank you, Neil. Thanks everyone for coming. I'm Cristina Ponce-Krauss. I'm from Puerto Rico. I am a law professor at Columbia Law School, and I am a legal historian. I've worked on the constitutional history of U.S. empire and U.S. territorial relations for some time. I've written on the insular cases of 1901, which I bet most of our audience knows something about, and have spoken and written as well on Puerto Rican status specifically. Fun fact, I somehow missed that it was supposed to be fun. I don't know how fun it is, but I guess I can say that I am often asked whether I was born in Puerto Rico. I look like my dad. He's of Irish descent. Maybe I don't really look like I come from Puerto Rico. And the answer always is I moved to Puerto Rico when I was 3 weeks old, not even a month old. My mom's Puerto Rican, and they just didn't get back quickly enough for me. So as it happens, I suppose I have 14th Amendment citizenship nobody's arguing with. So there's that. So I would like to say that even if they had moved back to Puerto Rico 3 weeks earlier, I would still have constitutional 14th Amendment citizenship. So that's me, Puerto Rican, raised and in my heart and in my family. And I'm very happy to be here.
Thanks. Rose, do you want to go ahead?
Sure, thank you. Thanks so much to all of you for being here and for including me in this discussion. I'm Rose Cuizan Villazor. I teach at Rutgers Law School. I primarily focus my research on citizenship and immigration, with a particular exploration of U.S. territorial relationships, both current U.S. Territories, but also former U.S. territories, including the Philippines. Fun fact, I was born in the Philippines, but I grew up on the island of Saipan. So Hafade, Zantito, Mabuhay to those of you who are from Saipan, Tinian, and Rhoda. And my parents were among the first wave of migrant workers from the Philippines who moved to the CNMI. And that's how my brothers and I got there. And then I'm a naturalized citizen. And so I think a lot of questions about citizenship, both from those who choose to become citizens, but also those who were born as citizens. And the last thing I'll mention is that my grandparents were US nationals when they were born because they were, at the time, they were born in the Philippines when it was a US territory.
Wonderful. Thanks so much, Rose. Sam, go ahead.
Hi, everyone. I'm Sam Merman. It's really nice to be here with all of you, with Neil, my co-panelists, everyone who made this possible, and with what looks like a really kind of amazing audience. I am a professor at the University of Michigan. I'm a legal historian of U.S. empire and citizenship. I've done the most work on Puerto Rico, although I'm now on a project that's trying to look at U.S. empire a little bit more broadly. And what I used to think of as a fun fact and, seems a little less fun these days, is I remember the first time that I went to Puerto Rico, uh, I had to convince like everyone at the airport that I didn't need a passport because everybody thought I was traveling abroad. Um, and then it turned out there were people checking passports when I got on the plane. Not mandatorily, I suppose, but like they were like, "Oh, this is our chance to check passports too," because everyone thinks they have to show it to us. And so I felt like I learned a lot in real experience about the thing I was studying at that moment.
Wonderful. Well, thanks everyone again for joining on. And want to just spend a few minutes at the start, kind of table setting the conversation for today. So the timing for us getting together to talk about these issues is that next week, the United States Supreme Court is going to be considering a case called Trump versus Barbara. And this is a legal challenge to the Trump administration's executive order 14,160, which purports to redefine the long settled understanding of the Citizenship Clause of the 14th Amendment to deny recognition of US citizenship to children whose parents are temporary or unauthorized immigrants. The challenge is based both on the Citizenship Clause of the 14th Amendment, but also a statutory challenge based on 8 USC 1401. Both of them have very similar language. The Citizenship Clause states that, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. And this really sets forth two key criteria or eligibility requirements for citizenship. First, someone has to be born, quote, in the United States. And second, quote, subject to the jurisdiction thereof. So kind of unpacking those two legal phrases, starting with in the United States, from the founding through the ratification of the 14th Amendment, all the way to 1898 with the Supreme Court's decision in Wong Kim Ark, there was a long settled understanding that the Citizenship Clause applied in states and territories alike. After the 1898 Spanish-American War, the acquisition of Puerto Rico, Guam, and the Philippines, the McKinley administration did not like that long settled understanding. So it acted unilaterally to redefine what in the United States meant to exclude people born in Puerto Rico, Guam, or the Philippines, even as it recognized that those people were nonetheless under the sovereignty and jurisdiction of the United States. What did the Supreme Court do at the time? Spoiler alert, as you'll hear more of, they didn't do anything. They stayed silent. Today, the question that the Supreme Court's going to be taking up over this next week is similar in some ways. From the founding until just a few years ago, there was a well-settled understanding of the Citizenship Clause that it applied regardless who your parents were, with some very narrow exceptions. This current administration does not like that. And so they've unilaterally, through executive order, redefined this long-settled understanding of subject to the jurisdiction thereof to exclude children born to parents of temporary unauthorized immigrants, even while recognizing they're fully subject to the sovereignty and jurisdiction of the United States. They're required to follow all U.S. laws. What will the Supreme Court do? We may start to get a sense of that next week, but we're going to have to wait till the end of the term to really know what the Supreme Court might do. We here at Right to Democracy filed an amicus brief in Trump v. Hawaii on behalf of 21 current and former elected officials and judges from the U.S. Virgin Islands, Puerto Rico, Guam, the Northern Mariana Islands, and American Samoa, asking the court in the amicus brief not to repeat the same mistakes it has made with respect to birthright citizenship in U.S. territories. We are very thankful to Patricio Martinez-Lampart and Paul Krieger at the law firm KKL, who served as our co-counsel, as well as all of the amici. The court argument was that courts should not defer to the political branches to define for themselves the Constitution's restrictions on their powers. Now, the amici we represented on the brief represent folks that identify as both Republicans and Democrats, and peoples whose views on political status range the full spectrum from full statehood to full independence to other possibilities. We don't expect that the Supreme Court will get into the question of birthright citizenship in the United States territories this next week as it considers Trump v. Hawaii, but how it decides that case may well inform its future actions and future interpretations with respect to folks in the territories. With that, from any other kind of table setting comments or other reactions before we jump into things further from the rest of the panelists? Great. We'll go ahead and get right on into it. So to get us started, I thought it would be helpful to have more of a deep understanding of what the text and history of the Citizenship Clause tell us about its meaning and scope. Sam Ehrman's a law professor who has filed amicus briefs before the United States Supreme Court, addressing the meaning of both the phrases in the United States and subject to the jurisdiction thereof. He's written numerous academic articles and books on these subjects. Sam, could you walk us through the history of citizenship in the United States, really from the colonial period through the American Revolution, onto the debate and ratification of the 14th Amendment, all the way up through the Supreme Court's decision in Wong Kim Ark. And Christine and Rose, feel free and jump in as Sam is doing that, because I know it is a lot of ground to cover. But Sam, go ahead, take it away.
Great. So we're going to we're going to breeze through some history here, but we're lucky because it turns out the rule is really simple and it doesn't change. So prior to the American Revolution, the British rule was that if you were born in the British Empire, and you owed allegiance at birth, then because you were subject to the king's jurisdiction and protection, you were a British subject. So if you were born in Virginia and you went back to England, you got to be as English as anyone else. After the Revolution, the United States adopted this rule of birthplace-based citizenship. And for the most part, it just operated without anybody thinking about it. So you went to vote and they wanted to know if you're a citizen. They'd say, where were you born? You would tell them, and you got to vote. There were some hard cases. One set involved American Indians, which were political communities that were recognized as non-U.S. sovereigns, but existed sometimes within U.S. borders and sometimes within lands the United States thought they got first dibs on if the tribes were to give them up. Um, and the eventual decision there was that American Indians would not be treated as U.S. citizens under the birthplace-based rule because they were born into a different political community. That community was operating on actual territory, and so, right, they were out. Um, Enslaved people were also an exception. The theory there was they were not people at all, that being enslaved moved you out of the category of person. And then the third tricky group was free African Americans. They clearly were qualified as U.S. citizens under the traditional rule, but there was a lot of racial prejudice at the time, and also there was a privileges and immunities clause that said that citizens of of one state got privileges and immunities in the several states. And so in the infamous case, Dred Scott versus Sandford, the Supreme Court not only held Congress lacked the power to bar slavery in territories, which is the holding that precipitated the Civil War and that everybody, right, immediately knows. It also held that free African Americans were not U.S. citizens. And the way it got there was to say, if they were U.S. citizens, they'd get all these privileges and immunities. Um, and then they looked at the founding, and Chief Justice Taney did some bad history and decided he thought at the founding free African Americans really had no rights, and so they couldn't have been intended to get these privileges and immunities. Other people quickly jumped in to point out that, in fact, free African Americans at the founding in parts of the country did actually have extensive rights, could vote, etc. Quickly, the Dred Scott case got overturned by the 14th Amendment, which came after the Civil War, and by the Civil Rights Act. And that got us our current system of it codified the old rule, which is birth within U.S. borders, subject to national jurisdiction, makes you a U.S. citizen. And the people who drafted and voted on it made clear that they thought they were preserving the old rule, not creating something new. And they had some conversations about what the limits of this were. And basically what they said was the the groups that were exempted under the common law rule going back, into the antebellum period and earlier are also exempted under the new rule because the new rule is the old rule. So that meant children of ambassadors were exempted, children of soldiers in an occupying army, and then children of American Indians in tribal relations were exempted. Then they also talked about some other groups there was a lot of racial prejudice against at the time, like the Chinese and Gypsies. And they said, look, they clearly qualify under the rule. No problem. So then after the amendment gets ratified, there's two cases that help settle a couple of things about the rule. The first is the slaughterhouse cases, which is most famous because it narrowed judicially enforceable privileges and immunities of citizenship, a different part of the 14th Amendment. But it also said, just in case you were wondering, if you're born in territories, that counts as born in the United States. So that was the rule going all the way back to the founding and before, and the Supreme Court had little difficulty affirming that. Then there was the case of Elk versus Wilkins, which raised the question of American Indians whose parents were in tribal relations. And there they reaffirmed what had been discussed in Congress, which was that if you are born into the allegiance of this non-U.S. sovereign, a native nation that is operative within U.S. borders, that means you do not get the birthplace-based citizenship. And that's why there was an Indian Citizenship Act in the 20th century ensuring birthplace-based citizenship for all American Indians. Uh, at this stage, the rules are pretty clear. Um, and what we then see in the late 19th century is a set of clever, pretty racist lawyers who decide they don't really like this rule. They would like to attack the 14th Amendment. One set of these lawyers are Democrats from the South who are into white supremacist causes. And then another set are anti-Chinese lawyers from the West. And they get a set of arguments that link them together where they basically say when the 14th Amendment says birth in the United States makes you a citizen, what it means is having citizen parents makes you a citizen. Um, that's kind of hard to swallow. And in order to make that sound more reasonable, they go and try to make two other big claims that were wrong at the time. So one was they claim the US Constitution tracks international law more closely than common law. And the other is they claim that international law requires that you use a descent-based rule instead of a birthplace-based rule. And in one of these echo chambery type things, lawyers cite each other, they come up with arguments, they get some other people in government to think maybe this is a good idea, they get a whole test case up and running, and in Wong Kim Ark versus the United States, the Supreme Court pretty muscularly strikes this down. They say, nope, common law is what we look to, not international law. Also, the rule you think is an international law isn't. Also, there's just, centuries of history and really clear text here. Um, the rule in the United States is birthplace-based citizenship, regardless of race. And so that's the decision in 1898. It's notable because if you were just looking at who the parties are, you would not bet on litigants of color winning constitutional claims in 1898. Um, but the court looks at this case and finds it easy enough that even as they're ruling in what to us looks like the wrong way in cases like Plessy versus Ferguson, they say this is a rule we're going to enforce. Even when it favors a very unpopular group like the Chinese, ethnic Chinese in the United States.
Rose or Christina, do you want to add anything to that history?
The only thing I would add, thank you, Sam. That was excellent. I always love hearing
Yeah, that's great.
about the history from you. The only thing I would add was that to provide additional context about in Wong Kim Ark, in that his parents were Chinese and nationals, right? Chinese immigrants, and they were not racially eligible for citizenship. So these contested claims about citizenship were also part of a larger anti-immigrant, anti-Chinese history that I think can be also connected with some of the issues that will be discussed next week in the Barber versus Trump case.
So this Wong Kim Ark decision comes out in 1898. Just literally a few months later, the United States goes to war against Spain, the Spanish-American War. Some of you might have read about it in your history books as the Splendid Little War. Christina, can you just kind of set the scene for folks? Walk us through, what was the Spanish-American War, what places were involved, how and when did the war resolve? What did the Treaty of Paris say and not say about citizenship? Can you kind of just get everyone on the same page there?
Absolutely. So I do suspect that a lot of this audience knows plenty about that war. So I will try to gear what I say toward the topic of citizenship in particular and kind of follow from what Sam has just said. I too love hearing Sam describe the history. And so what's so significant about the Spanish-American War, which is really the Cuban Spanish-American War, even that might not be the most accurate way to describe it, but very importantly, this is a war that was initially a war between Cuba and Spain for Cuba's independence. And the United States intervenes at the last minute. It had been watching Cuba certainly for longer than that. but it intervenes at the last minute in order purportedly to help liberate Cuba. And in the war resolution, there's a qualification. The United States promises not to take sovereignty over Cuba, but it doesn't make any promises with respect to other Spanish colonies, the status of which is going to be affected by this war. And sure enough, in the treaty negotiations, Spain cedes control over Cuba to the United States, but not sovereignty. And it cedes sovereignty over Puerto Rico, Guam, and the Philippines, with respect to which no promises about sovereignty had been made. Those treaty negotiations did not include representatives from these colonies. These are colonies, so of course they were denied a voice. And these treaty negotiations also broke with longstanding tradition. So they broke with longstanding tradition and settled understandings as Sam has described them. That is, the United States included the territories. People in the territories were considered citizens, and Wong Kim Ark had just recently confirmed a broad understanding of the birthright citizenship guarantee with narrow, clearly identified, clearly understood exceptions. And that's the key. The Citizenship Clause does have, there aren't really exceptions, they're built into the definition, but that phrase, and subject to the jurisdiction thereof, the key, as Wong Kim Ark explains, to understanding that phrase is it's not just an opening for us to have an endless debate about who's a citizen and who's not. The whole point of this guarantee is clarity, certainty, and universality. And then, yes, there are some narrow, limited, defined exceptions. And all the common thread with those exceptions is that there's another sovereign involved. And so there's attention to that fact in determining who's a citizen and who's not. So in this moment, in 1898, there's a break with this understanding, and also with a longstanding tradition since the founding that newly annexed territory meant citizenship for the inhabitants of that territory and eventual statehood. So there was a pattern, it was established, it was understood. The ultimate goal of statehood was understood as linked with citizenship. So the key here isn't statehood has to be the endpoint. It is membership, inclusion, rights. That's what is supposed to follow from citizenship. And so in the past, it was this question, it didn't really come up much. It was just, we annex territory, its people become citizens. There had been questions about conferring citizenship to African Americans, as Sam explained, but the assumption was citizenship applies. And yet in the treaty negotiations over Puerto Rico, Guam, and the Philippines, the language they came up with, instead of promising citizenship at some point, sort of acknowledging that citizenship is going to follow from annexation, instead, the language sort of explicitly left the question open. Like the language almost goes out of its way to say, we're not going to even answer this question right now. And so what Article 9 of the Treaty of Paris said was that the civil rights and political status of the native inhabitants of the territories that were being ceded to the United States shall be determined by Congress. In other words, we hereby kick the can. So we don't include the territories in these negotiations, and we don't decide what we're going to do about citizenship, which opens the door to what I think Sam is about to explain next, which is how all the branches get involved in tweaking, experimenting, and withholding the guarantee that people had expected would follow.
Thanks, Christina. So as you're previewing, you had this long settled understanding, the citizenship clause that applied to states and territories alike on the one hand, and on the other, this desire by the McKinley administration to expand U.S. empire without expanding rights or promises of political inclusion. Sam, can you explain that dilemma and how the Department of War and the Bureau of Insular Affairs sought to resolve it through what you've called in your very excellent book, Almost Citizens, quote, a revolution in 14th Amendment citizenship doctrine?
Sure. So the problem the government had in after it started annexing new territories was that it essentially wanted to run them like colonies. But after the Civil War, during the period of Reconstruction, a new conventional legal wisdom had taken hold, which was that we fought this war to ensure, certain ideals. Um, and those included the idea that all Americans are U.S. citizens, that they get a broad set of rights, and that those rights include political participation and, going back to an even longer tradition, that all places within the United States are eventually going to become states, even if they might start out as territories. Um, and so, what the Department of War and the Bureau of Insular Affairs have to do is they have to defend what's already been done in treaty and what Congress has sort of indicated a bit, which is a desire to hold the new acquisitions out at arm's length. And the argument they come up with is that Puerto Rico is not fully within the United States for constitutional purposes. Um, so the claim here is Puerto Rico's kind of made it into the US orbit, but it's not going to get the full constitutional rights. It's going to get some lesser set. It may never become a state, and folks are not going to get citizenship for being born there. But they want the United States to be enough within the United States, or they want Puerto Rico, the Philippines, et cetera, to be enough within the United States that they can say, um, hey, like foreign countries, you have to keep out. This is ours. And so the move is they start trying to come up with legal arguments that are going to allow the new acquisitions to exist in a kind of limbo so that they're just far enough away from the Constitution that they can't get the various guarantees that are found there, but they're close enough to the United States that they can't turn to another country in order to get rights there or belonging there or move within their sovereignty.
Thanks. And Christina, coming back to you, can you kind of talk about, what happened then as this conversation that was kind of started by the executive branch, what happened kind of across all three branches of the federal government? What actions, if any, did Congress take? How did the Supreme Court justices begin considering and talking about these issues in cases like Downs v. Bidwell? And what happened when the issue finally came more squarely before the Supreme Court in 1904 in the Gonzalez versus Williams case?
Sure. So as you said, every branch of government was involved in this process of crafting a sort of, as Sam put it, arm's length relationship, much effort to develop a legal framework that partially included and partially excluded. A legal framework of empire, right? This is what empire does. You're in for purposes of other countries meddling, but you're not fully in for our purposes, for domestic purposes, which is where the phrase I'm sure many in the audience are familiar with, foreign in a domestic sense, comes from Downs v. Bidwell, one of the insular cases, captures that sentiment. You're kind of in, but you're kind of out. You're here, but you're at arm's length. So what happens, what ends up happening is that Congress, in creating governments for Puerto Rico and the Philippines through organic acts. So an organic act creates a government. This audience, I think, knows that. In those, in the organic acts for Puerto Rico and the Philippines, Congress includes a provision, unlike any provision it had included for previous territories, in which it provides for a sort of sui generis form of citizenship. So in Puerto Rico, it labels the people of Puerto Rico citizens of Puerto Rico. And in the Philippines, it labels them citizens of the Philippines. So it's sort of a gesture, in a rhetorical gesture in the direction of some form of citizenship, some kind of membership. But of course, at the moment, the only sovereign capable of granting citizenship in some legally understood and recognized way in these places is the United States, which just annexed them. So it's quite a confusing move and very much conveys this sort of you're partially in, partially out message. Then the Supreme Court considers the status of the territories in the cases known as the insular cases, a series of them being decided in 1901. And then there are subsequent cases. And the most important one in 1901, Downs versus Bidwell, is the case that's associated with this phrase, foreign in a domestic sense. It is a case in which the Supreme Court essentially holds that the territories are part of the United States for some constitutional purposes and not for other purposes. And a key piece of these cases, which often gets lost, is that they did, or Downs in particular, is that it did concern a specific constitutional provision, the uniformity clause of the Constitution, which requires uniformity in the imposition of duties, imposts, and excises. And the court said that that clause, which uses the phrase United States, requires uniformity throughout the United States, did not constrain Congress in legislating for the territories, the new territories that had been annexed in 1898. And the most important opinion in that decision, which was the concurrence, crafted the doctrine of territorial incorporation, according to which these new territories had not been so-called incorporated into the United States, at least for purposes of the uniformity clause. The one unfortunate legacy of that decision, it's such a startling proposition that I think, people sort of took it for more than it even was, because it became, in people's understanding, sort of, these places aren't part of the United States. But that general proposition doesn't withstand scrutiny. It's more complicated than that. And what it did do was leave the government quite a bit of discretion to decide how to treat the territories on a case-by-case basis. The next case that's relevant, the only other case I'm going to talk about in this part of my remarks, is the Gonzalez v. Williams case in 1904 that Neil referred to. So once you've got this status for the new territories, they're sort of in the United States sometimes, not in the United States other times, they're in limbo, they're at arm's length, they're foreign in a domestic sense. The question then follows, okay, what about the people? What is their status? So the Gonzalez case, which I address with trepidation because my favorite scholarship on the Gonzalez case is by Sam Ehrman. But what are you going to do? It's my turn to talk. In that case arose when a woman who had been born in Puerto Rico prior to the annexation, but was living there upon Puerto Rico's annexation, traveled to New York and was stopped at Ellis Island and excluded on the ground that she was an alien, so not a citizen, and was likely to become a public charge, according to the standards in immigration law then and now. Actually, this is a criterion that the government considers. And she resisted this, arguing that the United States had annexed Puerto Rico, so she must be a U.S. citizen. Her case made it to the Supreme Court, and the Supreme Court really did not meet the moment. It did not step up. So Neil described the court as doing nothing, but I think that lets them off too easy. They did do something. They didn't answer the question they should have answered. So what they said was, under the immigration laws currently in place, people in this position, people from Puerto Rico, implicitly from the other territories, are not aliens, and so they can't be excluded. But by saying under the immigration laws currently in place, they left open the question of what happens if these laws change. In the meantime, they said they were not going to address the constitutional question of the citizenship status of people from the territories. And of course, in that case, you had somebody born in a territory before annexation. So there was also the question of, well, what happened after annexation? And all of these questions were basically left unanswered as the government started thinking of and treating the people of the territories as non-citizen U.S. nationals. So maybe I'm getting ahead of myself, so I'll stop there.
No, thanks, Christina. And Rose, thanks for your patience. Wanted to bring you in here as well. And your scholarship, you've written a lot about both the insular cases and other Supreme Court decisions like Wong Kim Ark and others that addressed issues impacting the Asian Pacific Islander communities. Would be interested to hear from you some of the parallels that you might draw between how the U.S. Justice Department and Supreme Court or Congress thought about people in these new island territories, how they thought about other marginalized communities of color, and just any kind of broader lessons from that historical time period you might connect or draw.
So first, I don't mind Sam and Christina talking about history because they're the legal historians, and I relied on their work so much, and so thank you for that preview. I do. There are some themes that I'd like to share between the race and empire over the U.S. territories and also what was going on in the United States, some of which Sam alluded to post-Civil War. I'd like to highlight four key issues. So one is that African Americans in the United States were also experiencing similar, very shared racism through Jim Crow and other forms of subordination and racial discrimination that was happening, and also based primarily on white supremacy, right? And so this race and empire ultimately was grounded on white supremacy that was also supporting the racial subordination of African Americans in the United States. So not only by the states, but also through the federal government's different actions that they undertook in the 1900s, around the same time that the U.S. territory, the Philippines, Guam, Puerto Rico issues there were, and American Samoa were also happening. Um, the second thing I wanted to point out, although the Philippines at this time, during this time period, was a U.S. territory, I did want to engage the status of Filipinos as non-citizen nationals within the context of U.S. immigration racial exclusion. So Filipinos, unlike Chinese and then later Japanese, who were excluded from entering the United States, first through the Chinese Exclusion Act, and then later through 1924, when Japanese nationals were also subject to exclusion. Filipinos as non-citizen nationals they were able to enter and migrate, right, from the Philippines to the United States. And then they formed communities in California. They went to Alaska. And what was interesting about them as non-citizen nationals is that they were not racially eligible to become U.S. citizens. But and the reason why is not so much because they were non-white and not that they were not. So at the time, you can only be a naturalized citizen if you're a person who is white or of African descent. But that wasn't the main reason why they could not become citizens. It's because they were, quote, subjects of the United States. They were not aliens, right? And so that prevented them from becoming US citizens. So that's the second kind of theme that I'm seeing here with respect to race and empire. And then for other people of color, here. So I've mentioned already Asian immigrants during this time period. There are also the treatment of Mexicans who were at the time able to move back and forth between Mexico and the United States to work as in the agricultural fields. They were able to, in some ways, move back and forth, and some, because they were constructed as white people, some were eligible to become to apply for naturalization. But that too, we were seeing here how citizenship was being used as a tool of exclusion. It was used as a tool of empire that we saw in the U.S. territories, but it was also used as a tool of exclusion from membership through different cases where one had to litigate and prove that they were white in order to then be able to be eligible for citizenship. So I think it's important to connect the dots with the different subordination histories that all of these different groups experience because it helps us to better understand how citizenship has been formed and how it's been what it meant at the time and how we can move forward today in addressing some of the problems that emanated from this racist history.
Thanks, Rose. So kind of moving forward chronologically here, after 1898, or at the time of 1898, the terms citizenship and nationality were treated as interchangeable. But after this extension of empire became this idea of people who were US nationals but not US citizens, meaning they had the full obligations of owing allegiance to the United States, but not the full rights that came with that. Sam, could you talk briefly about how what you described in some of your writings as the Supreme Court's strategic silence on this question of citizenship opened the door for the political branches to establish this new category of so-called non-citizen U.S. national?
Sure. So the Supreme Court finds itself after 1898 caught between, on the one hand, not wanting to make this new imperial project a failure, and on the other hand, not wanting to betray the US Constitution. Um, and their solution is to try to evade or to avoid coming up with a clear statement of how to fit these two things they don't know how to fit together. So they don't really clarify, for instance, what constitutional rights you get in Puerto Rico or the Philippines, though they say something less than all of them. Similarly, in the case Christina talked about, the Gonzalez versus Williams, they have an opportunity to say whether or not being born in Puerto Rico or being Puerto Rican would make you a US citizen, and they avoid it. So they say, look, you're not an alien, you're not foreign, and so that means you're at least a national. And then they say, not, and hence a citizen. Instead, they say, and we're just not going to decide whether or not you're a citizen. And that's kind of where things have been now for, 120 years or so. And this is a powerful thing for the court to do because it's sending a signal to the rest of the government. You can go ahead and treat people in the territories in ways that we might not be willing to sign off on constitutionally, but we're not going to get in your way. We're just going to stay quiet. And the agencies and the political branches get the memo. And so they start first in the agencies and eventually in Congress, creating this middle category of people who are neither citizens nor aliens, non-citizen nationals, which is not a category that people in the United States understood to exist in the period before 1898.
Great. And so, Christine, going back to you, Christina, all of this is being done at this stage really through the executive branch. The Congress is recognizing people in Puerto Rico as Puerto Rican citizens or people in the Philippines as Philippine citizens, just being silent on this question of whether they are US citizens at all. Can you talk a little bit about how Congress has legislated in that space at that time, and then kind of moving forward with these statutory recognitions of citizenship? Again, without a full consultation, even of people in the particular territories, or sometimes even addressing these broader issues of political status or self-determination that are also important questions to have. But maybe starting with Puerto Rico, you can, and maybe the Philippines is a good starting point too.
Sure. So I think that the theme I want to kind of hammer away at is that sort of limbo space. Like every move we see here confirms the discretion and power that the federal government has, and the way in which this legal framework of ambiguity and discretion leaves what should be a clear, certain guarantee to, drip by drip, case by case. And so what we have is in 1917, after a complicated 2-decade history of grappling with the question of citizenship by people in the territories. Sam Ehrman's book tells that story vividly and compellingly for Puerto Rico. Congress finally decides that it is ready to collectively naturalize the people of Puerto Rico. So, per the Jones Act of 1917, Congress provides for U.S. citizenship in Puerto Rico. That, on the one hand, is a step toward inclusion, and on the other hand, at this point, the United States has been governing Puerto Rico as a colony and unilaterally, and not really not giving people a real voice, and so it's hard to kind of wrap one's mind around what message about membership it conveys to confer citizenship upon people who you're still not fully including and still not making full rights-bearing represented citizens. In 1922, there's a case in the Supreme Court, Balzac versus Puerto Rico, in which it involves the applicability of jury trial rights in a local court in Puerto Rico. But as far as citizenship goes, observers think that if Puerto Ricans are U.S. citizens, well, now Puerto Rico must be part of the United States for all purposes, right? Isn't that how this works? And the court takes care to say, no, no, no. You may be citizens, but you're still in that same limbo status of sometimes part of the United States, sometimes not. It's up to the government to decide on a case-by-case basis. So over and over, sort of digging in on ambiguity. The Virgin Islands are annexed in 1917 with a promise of citizenship in the treaty, and then that citizenship is not forthcoming for another decade. So it takes until 1927 for that grant to come. In 1940, the Immigration and Nationality Act designates the people of Guam and American Samoa non-citizen U.S. nationals, and it's not until 1950 that the people of Guam are collectively naturalized by Congress. And so it's really a step-by-step Congress gets to decide, which, if you think about it, is really just the opposite of what the Citizenship Clause aims for and aspires to. So it's this gradual, even if you think of it as inclusion, there's always this problem, which is why is it that Congress can decide this by legislation? I'll say one more thing about the Immigration Nationality Act as it looks now, if I'm not getting ahead of myself, stop me if I am. But apropos of this limbo and governmental discretion that empire facilitates, the INA defines the United States as including all of the current territories except American Samoa, except as otherwise herein provided. Then when you go to the citizenship provisions of the INA quote the 14th Amendment. So you think, okay, well, all persons born or naturalized in the United States, and for immigration purposes, the territories are part of the United States, but not so fast. Then you see that in the provisions following that initial set of citizenship provisions, the territories are provided for separately. So it's just in the INA citizenship provisions an illustration of how we include, we exclude, we include, we exclude. So I think you've by now gotten a sense of my own obsession with this topic.
That's great. And the Northern Mariana Islands kind of offers its own unique kind of history on these issues. This week is an important week in the Northern Mariana Islands. Their covenant forming their political relationship with the United States just turned 50. And there's some interesting ways that it addressed questions of citizenship. Rose, if you wouldn't mind talking a little bit about some of that, would love to hear it.
Yes, thank you. So happy 50th anniversary of the covenant. I had heard about this celebration and commemoration of the covenant. The covenant was signed by President Gerald Ford 50 years ago, and it established this political agreement between the Commonwealth of the Northern Mariana Islands and the United States. There's a long history of how the Marianas got to its current status. I don't have time to talk about the Trust Territory Pacific Islands and how the Northern Marianas delegates were part of that initially and then split off and negotiated for their own political agreement. But that's what I want to actually focus on, is that unlike Puerto Rico, Guam, the Virgin Islands and American Samoa. Well, the American Samoa was its own case, I suppose. The Northern Mariana Islands were able to negotiate, or at least negotiate their membership, in that they wanted to include U.S. citizenship as part of the package of becoming a U.S. a Commonwealth of a U.S. territory, Commonwealth of the United States. And so that, I think, is an important factor to consider as we discuss the discussion of what citizenship means in the CNMI as compared to, let's say, the other territories. The other thing that I thought would be also helpful to talk about is how we can distinguish the experience of the CNMI people with people from the Philippines, who in the Philippines, they never actually wanted to become a U.S. territory. They were annexed, and the people thought that before that, they thought they were going to be an independent country, but they were not. And they became a U.S. territory and conferred with this Philippine citizenship, then later non-citizen national status, but they always wanted to become independent. And so Congress then decided in 1934, because Congress apparently has the power to decide on citizenship of people in the territories, Congress decided to then put the Philippines on a path towards transition, which was what many in the Philippines wanted, a transition to independence. So there was this 10-year transition towards independence. Filipinos at that time, by 1934, those in the Philippines were then regarded as, quote, aliens. But there were thousands of Filipinos already in the United States. They maintained their non-citizen national status, right? So Filipinos did not really have a choice. The Filipinos in the United States at the time did not have the choice to determine for themselves what citizenship status they might have, even though they were born at the time in a U.S. territory and they migrated to the United States. So the CNMI can be thought of as an example of what happens when people are given the opportunity to exercise their right to self-determination and be able to negotiate what might be the terms of their agreement. And one of the key points that they negotiated at the time was to have protection over their land their land protection of their land, so that there would be a restriction on the alienation of their land only for people of Northern Marianas descent. But to close, this U.S. citizenship was part of the package deal that the delegates of the Marianas District did, or negotiated for, during the covenant of political discussions.
And I think that's a great transition to talking about American Samoa and issues of citizenship there. They share with the Northern Mariana Islands similar restrictions on land ownership. You can't, I could not move to American Samoa and purchase land the same as I couldn't move to the Northern Mariana Islands and purchase land. A difference in American Samoa and the history of citizenship is that when the leaders in American Samoa signed deeds of cession in 1900 and 1904, transferring sovereignty and making this choice to transfer sovereignty over their lands to the United States, they did so with the understanding that with that transfer of sovereignty would come a recognition as full U.S. citizens. They didn't learn that the United States was not upholding that side of the deal until about 20 years later, when the U.S. Navy told them they weren't citizens, but instead this category of non-citizen nationals. For the next several decades, they pushed to be recognized as full U.S. citizens, really all the way through until 1960. Expressing, as the case of the Northern Mariana Islands shows, that you can have recognition of citizenship while still having protection of land and culture. But after around the 1960s, their leaders really stopped pushing for U.S. citizenship, more recently even imposing the judicial recognition of citizenship in some cases that I've been involved with, raising these concerns about the recognition that citizenship could threaten their ownership of land or other cultural practices. So I'd be interested in hearing more from you. You've written about citizenship, you've written about culture uh, within American empire. Would be interested in hearing you talk a little bit more about how you see these issues intersect across territories and kind of across different themes.
Well, at the outset, it's very important for Indigenous peoples to be able to have ownership and control of their land and be able to make a decision whether they want to open up land ownership to non-Indigenous peoples. So I can understand why in the CNMI context they wanted that to be part of the covenant and the negotiations at that time. I can of course understand American Samoans through the deed of cessions. They understood that land must be protected and that because that was important to them. Culture changes over time, right? That's the very essence, that's the definition of culture. And so some of the questions that I think can be raised in the CNMI and American Samoa would be, to the extent that culture is changing, what does that mean in terms of land ownership? And then who gets to decide? And that's something that has to be worked through the political processes of those places. Um, you mentioned the imposition by judicial fiat of citizenship on more recent claims made by American Samoan leaders. I mean, you've read my piece on this. My position is that people can change their minds about what they wanted for citizenship, and if the current leaders right now think they're representing that this is what the people don't want, that they don't want citizenship, I don't think I'm in a place to be able to say, well, I just don't think that's the right call. I believe in them being able to make that decision for themselves. It does raise a separate question, though, about whether the Constitution can be um, divided in that way. There's a question in the chat or in the Q&A about some of the conversations seem to presume that people want citizenship, that yes, there's race and empire, but what about the choice of choosing citizenship? And I think the American Samoan cases, some of the opinions there, some of the writing about whether citizenship can be rejected or not. Those are really important and complex questions that are tied with cultural and political claims.
Yeah, and as you know too, in American Samoa, there's also contested questions around the application of marriage equality. Their government is the only government in the United States that does not recognize marriage equality, relying on some of the same arguments that have been raised with respect to citizenship. Also, is a recent case about the Second Amendment. And then, of course, there's the broader and really overarching question of political status and self-determination. And so, this conversation we're having today, it's really focused on what are the restrictions on the power of the federal government when it comes to places under their sovereignty and jurisdiction. There's a separate and one might say even more important question of what does self-determination mean? What does decolonization mean? We have many panels and conversations where we talk at length about those issues. But really here, and this is going to be a question coming up next week at the Supreme Court too, is who gets to decide what those restrictions on the federal government power are? Is it the political actors themselves, people like the president or Congress, or is it the courts? And that's kind of the overarching conversation we're having here today. Sam or Christina, do you have any other reactions on any of that before we move on to the next section?
Yeah, I can hop in for a second. So I noticed in the chat one question was about what happens if you have citizenship in territories and then the territories decide to opt for independence instead of staying within US sovereignty. And that one, it turns out, the sort of longstanding law has an answer for, which is independence carries the people with it. And so the the norm is the people who live in the territory that becomes independent trade their citizenship in the old sovereign for their citizenship in the new sovereign. There's some complications around that, right? What about people who want to opt for something else or who are living abroad or who are living, in a different part of the old sovereign? Um, but it turns out like this is not a new question in the world, and so this one has been worked out a bit. Um, the other thing,
including the American independence.
right,
Yeah.
and very importantly, the other thing I just want to point out is uh, the question of is getting citizenship itself, how does that relate to questions of self-determination and decolonization, uh, is hard to separate from the history we've been describing of the way in which territories are put into this limbo status where it's both, they're neither fully in or fully out, but also it's not entirely clear what the rules are. So it can seem like the very same thing might get you valuable rights, or it might cause you to lose something very important to the way your polity works or that's cultural. And so uh, the fact that we went chronologically does create a little sense of, oh, everybody wants citizenship. That's partly because chronologically you start with the period where there's lots of people who are seeking U.S. citizenship. And so that's the way it's going to look. And then the very processes of holding that question at bay and creating ambiguity also contribute to a politics of thinking, well, maybe there's some real downsides to this, or maybe this is getting in the way of self-determination. And so it's, I think, useful sometimes to historicize that a little bit too.
And Christina, maybe jumping ahead, kind of while we're on this conversation of citizenship and self-determination, wanted to kind of unpack uh, how there has been uncertainty around this issue and what position the federal government has taken from the Department of Justice to Congress. And then what does that mean as people think about questions of self-determination, about, having a close relationship with the United States, having a separate relationship. But maybe starting with, if you can talk about, what position the federal government has taken through statements from DOJ in court, in Congress, congressional reports like the 1996 Congressional Report on the Puerto Rico Status Act. Can you just kind of talk through a little bit what the position of the federal government's political branches has been with respect to this so-called statutory citizenship?
Yeah, sure. So I don't think there's been as much clarity as would be ideal. So I think so. I agree with Sam that there is a history here on the effects of a change in status on citizenship, but I want to qualify that statement. So it's true. Citizenship follows the sovereignty. So if you become independent, well, then the practice has been you acquire the citizenship of that country. Now, there's also a long-standing tradition that Sam also alluded to of the new sovereign providing a right of election. That is the right to choose whether to acquire the citizenship of the new independent country or to retain your old citizenship. With that right of election, sometimes sovereigns have required that if you're going to retain a prior citizenship, then you have to relocate to that citizen's territory, so that sovereign's territory. So, for example, when the United States annexed Alaska, it provided the right of election and it required persons who decided to keep their Russian citizenship to leave. But when it annexed a large part of Mexico, it provided the right of election and did not require people to leave. So the theme of the power of the sovereign to determine their membership comes up over and over and over, which again, I want to keep hammering away at that, because the citizenship clause is all about creating a space where the political branches don't have that power. So, and this is maybe a little bit of a response to Rose too. So on the one hand, as much as possible, people ought to be able to choose their membership. On the other hand, the way I see it, I don't think Congress has the power not to grant citizenship to people who are born under U.S. sovereignty. I don't think it does, and I don't think it should. And so I think that the task, that the real challenge is, how do we conceive of a citizenship that is inclusive and diverse? But what I don't want to see is, on the margins here, well, Congress can maybe curve those people out. No, Congress maybe can curve those people out, and then the next thing you know, Congress is, feeling its oats. Is that the phrase? Seeding its oats, feeling its oats, whatever it is, excited about its powers. And the next thing, so that's, it's keeping an eye on what the political branches think they can and can't do, and ensuring that they don't overstep. And that, because when they overstep, it's so often in the direction of exclusion. So how can we find a way for citizenship to coexist with cultural practices that frankly shouldn't be inconsistent with citizenship, and I would argue aren't inconsistent with citizenship? That's kind of where I come to it. So, but I don't think I'm quite answering Neil's question. So I'll just say a few more words about Puerto Rico, and then I'll wind it down for this bit. While I agree with Sam about what the tradition has been, for what it's worth, the recent legislation on Puerto Rico's status, there's been legislation passed in the House in 2022, then it was reintroduced. There have been some variations from bill to bill, but in recent self-determination legislation, bills rather, it hasn't passed, but bills on Puerto Rico, the government has taken the position that if Puerto Rico becomes independent, people who already have U.S. citizenship won't be forced to choose. They won't lose it, which I think is a righteous position. I also think that there should be some kind of transition that makes sense, but I'm not going to do a deep dive into status. All I want to say is the government has the power to say you're all going to be citizens of Puerto Rico because the United States controls U.S. citizenship, unless we have a clear decision that the citizenship clause applies there, which I believe it does in territories. But if we don't get that, then the federal government will see itself as having the power to say, all right, if you become independent, then you're all citizens of Puerto Rico or wherever the place may be. But it's not required to do that. The government does have the power to say, we'll allow you to keep your citizenship. Government has the power to continue granting citizenship for as long as it wants, wherever in the world it wants. And this is the key, because it's so many sort of false promises and so many promises that haven't been kept. It's so important for people to understand. If there's a change in status, the government can keep granting citizenship. It can recognize dual citizenship. It can pretty much do what it wants. And that means it can also stop granting citizenship. It can stop recognizing dual citizenship in the future. And so when one makes a choice about status, when a people make a choice about status, they are making a choice about which sovereign is going to have control over their membership. And that's something people need to understand and live by. And so Puerto Rico is going to have separate sovereignty. So I'm just thinking about Puerto Rico because that's what I think about most of the time. That's going to mean, well, the United States has control over its citizenship and Puerto Rico will have control over its citizenship, and people need to know what they're getting into. So every sovereign having the duty to recognize the full membership of people born on the territory that sovereign claims, has control over, I think it's a critical constraint on political power. It's one place I don't think political branches ought to be able to go and play around.
And related to that, though, Christina, were there to be a recognition of constitutional citizenship, that would not prevent the exercise of self-determination of Puerto Rico or Guam or the NMI to choose at some later point, well, we want to now be independent and pursue independence. Simply because the United States has recognized they have a constitutional right to citizenship, it wouldn't minimize, reduce, or void that right to self-determination that people in each of the territories has. Is that right? Yeah.
Absolutely. And if I may have said something that implied otherwise, so I'm glad you asked the question. And just to be clear, no, if the citizenship clause were to apply to, or to be held applicable to any of the territories, that absolutely doesn't get in the way of self-determination. People continue to have the right to self-determination, and the sovereign, in this case, the United States, continues to have the power to and the obligation to respect it and to act accordingly. And so, despite the fact that the United States would retain control over its own citizenship, except where it remains a sovereign, It absolutely does not get in the way of people exercising their right to self-determination and choosing whatever status they're going to choose.
And maybe on a related point, and I know there's sometimes been confusion about this. You've written a lot about how the insert cases, a lot of what they stood for was kind of changing this assumption of, well, what path are our territories headed towards? And Sam talked about how there was this historical understanding that, right to citizenship, a path towards statehood, that shifted with this incorporation doctrine. But whether it was before 1898 and the insert cases or afterwards, the Constitution still provides Congress the power to, in the Territory Clause, quote, dispose of territories. So even if there were to be a recognition of citizenship, even if the insular cases were overruled, that would not prevent the ability of people in the territories to exercise self-determination and move towards independence if they wanted to have Congress, to work with Congress to have an agreement where sovereignty was transferred from the United States to folks in the territories. Can you just talk a little bit about that? Because sometimes I think people kind of get hung up on, well, if there's recognition of citizenship or if the insert case is overruled, that means only one solution is possible, and that's statehood. And so this is all against any notion of self-determination.
Way to throw a huge one at me here at the end, but real quick. It is my opinion, my considered view that absolutely, if the insular cases were overruled and suddenly there were no incorporated or unincorporated territories, there were just territories, and we were back to it looked like it looked before, which is territories were all in one category. The fact that territories all used to be on the way to statehood absolutely doesn't mean that territories have to be on the way to statehood. What would happen is simply that the United States would continue to have the power to govern them as territories and to cooperate in a process of self-determination. My own view is that the language of the territory clause is less important. That power to dispose of, I suppose, can be read that way, but it's less important than quite settled understandings of the power of sovereigns and the international right of self-determination, and
the United States is adopted.
Yes, that the United States is adopted, and the broadly recognized view that a place that's governed in a subordinate status has the right that should be respected to choose a future status that is non-colonial, and to exercise that right and have it implemented by the sovereign that claims control over it.
Great. And as we're kind of closing out here, I'm going to shift to talking a little bit more about the implications of all this for next week's Supreme Court argument, but did want to encourage people to take a look at the amicus brief we filed, which really does unpack in great detail what positions DOJ and Congress has taken with respect to these questions. They've expressed the view that under the statutory citizenship, that not only can Congress choose to stop recognizing children born in U.S. territories moving forward, but they even have the power through a combination of the insert cases in Rogers versus Bill I to retroactively deny citizenship to people who have been recognized as citizens their whole lives. This is a very bold legal claim that certainly hasn't been tested, but it's very troubling that this is the repeated expressed view of the political branches in this world where their power is not constrained by the Citizenship Clause. So moving on to kind of our last section, and we'll open this up to just everybody, and we can try to get in, some of the outstanding questions maybe in this time period too. Looking ahead to next week, how do you think the U.S. Supreme Court should think about, or maybe not think about, the experience of U.S. territories as it considers this question of what does subject to the jurisdiction thereof mean? What does this executive order mean? How does all this fit together as we wait for the Supreme Court argument next Wednesday before the Supreme Court?
I think I'll jump in and just echo what Christina said earlier about what happens when political branches have power to make decisions about citizenship. And here I'm speaking specifically about the citizenship clause, because in the Barbara versus Trump case, the question there is whether the executive order is lawful and able to deny citizenship to people who are born here, upending all this history that we've been talking about. And so the experience of the former and current U.S. territories about how they acquired U.S. citizenship by statute, um, and is grounded in Congress's power as opposed to the citizenship clause right now. It is something that needs to still be considered. It tells us about what happens then, the instability of citizenship and what that means when power is being exercised by the political branch in a way that could lead to the subordination of people. And in the Barbara versus Trump case, subordination of children of immigrants, whether temporary or unauthorized, in the United States.
Sure, I'm happy to jump in too. And say if I could give advice to the Supreme Court, right? The advice I would give is don't freelance and make stuff up. Like, a lot of the troubles that are created are when they try to sort of come up with some new term they haven't thought all the way through. And when you're not thinking about the implications, it's often the spots that aren't front of mind that get it fits worst for. And so I think often the territories are not front of mind for the justices. And when they do something a little bit on the fly, it can sometimes have unforeseen effects there. And so, I kind of hope they avoid that in this case.
I guess I'll quickly just jump in just to say something about this case, which is I cannot help longing for a recognition by the court that this is a long settled understanding for a reason. I mean, this is the kind of question that needs to be both settled and settled right, and the settled is very important, and it was settled right. And so I guess maybe I'm agreeing with what Sam just said. Amen to what you both said. Yeah, there's a reason this is a long-standing understanding, and it should not be upended. Certainly not this way. I also just want to say I was trying to grab some of those questions from the Q&A, as you said, Neil, but I do have a hard time focusing on this and reading those, and that's part of why I haven't addressed many of those questions.
Great. Well, why don't we jump into some of these questions now? And there have been a number that have talked about, maybe recognizing citizenship does in fact put a big thumb on the scale in favor of one direction or the other. I responded in text quickly to one, suggesting again that the historical context of the United States itself is a good example of how that transition can happen. And so people in the 13 colonies were British citizens. They called them subjects at the time. Sam could be a little more technical on that. But there was no sense that's like, well, because you're recognized as citizens, there is no ability to become independent. The United States declared its independence, became independent, and then there was a fairly orderly process to sort out, well, who are U.S. citizens, who remain citizens who remain British subjects. There were Supreme Court cases addressing this right of election that both of you have been talking about. And so the common law understanding on these rules is relatively clear in terms of what the rights are, what happens when there's a transfer of sovereignty. And that goes back, even into the Supreme Court decisions from the 1800s. But would be interested maybe in Sam or Christina or Rose talking a little bit more about how this question of citizenship, while very important for understanding the restrictions on the federal government's power, does not speak to or answer questions of what rights do people in the territories have with respect to self-determination, decolonization, whether or not they're recognized as constitutional citizens or statutory citizens or non-citizen nationals.
So I would just real quick add to what you've said, Neil, just by saying that. So I agree with what you said, but also I just think that there unfortunately there is no such thing as self-determination from behind the veil, from a place where there's no finger on the scale. So the question says, interim birthright citizenship would place a finger on the scale for a territory deciding what to do next. The fact that they all have already statutory birthright citizenship, or in the case of American Samoa nationality, itself is a finger on the scale. It's the fact that they were annexed 125 years ago. That's another, well, some of them, another, or most of them, another finger on the scale. Self-determination, you're coming from a colonial place. That twisted, complicated, subordinate, in, out, we're here, we're not. In Puerto Rico, there's a lot of support for continued U.S. citizenship across status options because, forever people have been able to move to the mainland and work. And, why shouldn't they want to do that? So regardless of how they feel, in their sort of hearts about the American flag, they might want to retain citizenship for that reason. So one has to be able to proceed with self-determination from the position that one is in. And I certainly think that anything that tips the scales in an unreasonable way, in an unwarranted way, in an objectionable way, well, okay, that shouldn't happen. But if people, ought to have citizenship by birth based on longstanding understandings and what we think about sovereignty and allegiance and protection and so on, I don't think the fact that self-determination might happen later should prevent it, and it won't prevent self-determination.
And here I think I just want it's the Covenant's 50th anniversary. So it's a reminder of how self-determination was exercised there. Birthright citizenship was part of it. But if somehow the Citizenship Clause did apply, it wouldn't have taken away the covenant, right? So I think that's kind of the story here of how we can they can coexist. It's been done in the Northern Marianas. They chose to become a U.S. territory. They chose to become citizens. But if the Supreme Court had held that the Citizenship Clause does apply in the U.S. territory, it wouldn't have taken away the covenant because there was a negotiation between the Marianas people and members of the United States. And that's the hope, is that the other territories will be in a position where they can also exercise their right to self-determination.
So maybe I'll just jump in. I like those are great comments. The I think it is true that how citizenship is given or not given, withheld, extended, imposed, influences how status decisions will be made. So one reason uh, giving citizenship in Puerto Rico in the early 20th century became more popular was it was thought that it would um, sort of take the fire out of pro-independence sentiment at the time. And I imagine that withholding citizenship when people demand it makes people less excited about the metropole, right? And you can imagine many variations on this. Pushing citizenship at a moment people don't want it, et cetera, right? You can come up with, but I guess I agree a lot with what Christina said about there's no neutral position for this, and citizenship does matter. And I guess the other thing I've struggled with myself in thinking about this a little is on the one hand, the there's the doctrinal meaning of citizenship, the idea that if you get citizenship, then it forces this decision, or then it forecloses this, or it triggers this constitutional provision. Um, I've had trouble seeing a lot of those arguments because citizenship often, like many of our rights and constitutional rules and stuff, just are formally not related to citizenship. Uh, but, at a time of massive constitutional change, um, I think it's also a bit hard to be overconfident about these things that, like there just seems a lot up for grabs constitutionally these days. And so I find that like is a little bit tricky in trying to think about citizenship in terms of what I think, but also um, in terms of kind of how one thinks about how other people think about it, right? There's just a lot of moving parts.
And I think that's maybe a good ending point to kind of highlight how, this is not, as we're academics here having a conversation today. This is more than an academic question. This claim of power that Congress and the executive branch have taken, where, they say that, quoting language from this report, that, they can that citizenship could be restricted, modified, or even withdrawn, so long as there's a legitimate federal purpose for doing so in a territory while maintaining sovereignty and jurisdiction over a territory. It's a very troubling and kind of unlimited source of power at a time when you have this current U.S. Department of Justice expressly saying that denaturalization is one of its top priorities, one of the issues flagged in the comments. There have been, just in the last couple of weeks, there was a Senate Judiciary Committee hearing where the issue of birthright citizenship in the Northern Mariana Islands came up in the context of so-called birth tourism. A letter from senators to the executive branch on that question, signed by then Senator Mullen, now DHS Secretary Mullen. So these are issues that are within the political discourse. And these positions by the political branches sit there unrebutted so far by the Supreme Court. So all that is to say, the stakes are high for everyone. Come next Wednesday, tune in to the Supreme Court arguments in Trump v. Hawaii. We really appreciate all of your participation today, the panelists. We still have over 100 people on the webinar. Great participation. Really appreciate all of it. And these conversations will continue. We'll follow up over email with some additional information for folks from this webinar and looking ahead to future ones as well. So thank you all very much. Have a wonderful evening or morning, and we'll look forward to talking more about these issues more in the future.